My name's Jessica Schlager. The first thing I want to talk about is our new documentation that we have. So the new requirements for public notice of application comes directly out of the Responsible Energy Development Act, Section 31 of RETA. We call this public notice of application, so throughout the presentation I'm either just going to say PNOA or public notice. That's what I'm talking about. In addition to that, we've now got Section 5 of the Alberta Energy Regulator Rules of Practice. These came into effect along with Section 31 November 30th. And these outline more specifics for us to be able to adhere to our legislative requirement for public notice. So once the AER receives an application, additional public notice is provided through a dedicated web page at aer.ca. This is under Systems and Tools. It's a tool unto itself, and I have a screenshot of it a little bit later on. It's a new notice provision. It improves and enhances on existing notification and consultation requirements. It is not meant to replace these at all. Any existing requirements in Directive 56 or any of the other directives are still in place. Currently, our public notice, which was just released, was just developed and just released. Currently, the system includes lots of applications that the public is really concerned about. Obviously, surface facilities, oils, gas, pipelines, all the coal mining stuff, in situ, oil sands. Now, obviously, this is just the first iteration of this tool, and as new things come in, such as the PIA and Water Act, and as we are able to refine and develop this tool even better, it will have a lot more functionality than it currently has. Public notice of application includes details such as the company's name and contact information, a description of the energy resource activity, legal description or GPS coordinates of where the thing is located, information about the project, details on how to submit a statement of concern. These are all things that are outlined right in our rules of practice that says what has to be included in a public notice. Now, under Section 5.2 of our rules of practice, it outlines how long things need to be posted for, as well as how long anybody has to submit a statement of concern. Now, there's a number of applications that will be approved on an expedited basis, and the full list of this is outlined in Section 5.2.2 of our rules of practice. And what this means is we can go ahead and approve these applications when they're ready to be, or I guess disposition these applications when they are ready to be dispositioned without having to wait any amount of time. Things that are included under this list of expedited applications are routine applications under Directive 56, some of the applications under Public Lands Act, including EAP and TFA, and the applications where, in the regulator's opinion, adequate notice of the subject matter has already been given, where in the regulator's opinion there is no environmental impact, little or no environmental impact. So there is a full list there. And again, this list expands once we bring in more of the specified enactments under Water Act and APIA in March. For any applications that don't fall under this list of expedited applications, the AER must wait until the 30-day period has expired for us to approve the application. Waiting this 30-day period allows stakeholders an opportunity to file a statement of concern prior to a decision. In a lot of cases, especially with specified enactments, it's my understanding that they don't actually have the consultation requirements that are in some of the directives, and so this allows additional information for the public to make themselves aware. So as I said, here is a screenshot of our Notice of Applications page on the AER website. It's under the Systems and Tools. It's searchable by keyword or by location down to the section. And this is surface location, not bottom hole. On the left-hand side, you see you can filter by different groups, wells, pipelines, surface facilities, oil sands, etc. It also allows you to filter by company, which are companies that currently have notices up being published. And as you scroll down to the bottom, it also allows you to filter by the date it was received. Notices of application are published for 30 days, and after that, they are no longer published or available on our website. On the right-hand side, we currently have the Public Lands Act amendments and applications, which currently is a PDF. Within the next couple of weeks, we are hoping to make some improvements to the system, which will then display all of the Public Lands Act applications in this same format and searchable in the same way. All right, let's get to what everyone really cares about, statement of concern. So just so everyone is aware, and I'm sure you are, the old ERCB used to use the term objections. Under the new legislation and under the new AER, and that term has been retired, and we now use the term statement of concern. Any Albertan concerned about a particular application may submit a statement of concern. It has to be in writing. It can't be a phone call, and it can be filed by anyone who believes they are directly and adversely affected by an application. We will generally only register and process statements of concern if they contain specific information about the application. In order for it to be registered, it has to include the name and contact information of the person filing, the name of the company, the type of project, the location of the land and proximity in relation to the proposed activity, summary of concerns, how this does affect them, how they believe they're directly and adversely affected, and any history or background that will help us understand this. The AER does review all statements of concern filed. Whether they are capable of being registered or not, all of them are read, all are reviewed. If the statement of concern fails to demonstrate that the person could be directly and adversely affected, or if it's not filed within the timeline specified, or if it's unrelated to the specific application, or if it relates to a policy decision, the AER may decide that this cannot be registered and will notify the person accordingly. When we're talking about statements of concern in relation to expedited applications, we recognize it's possible that in some of these applications, they could be approved before the statement of concern is registered with the AER. If this occurs, we of course will still review their statement of concern to make sure that it is a valid one, and we will respond back to them to let them know it has been reviewed and to outline the requirements for a regulatory appeal if they believe that that's the way they can go and if they are eligible for one. The other things the AER can do is look at the statement of concern and see perhaps if it's related to a compliance matter. The AER can choose to do a review of the original license if they think there may have been a concern there. So for all of the other applications that are under that 30-day period to file a statement of concern, we will review those that come in prior to the 30 days, and it may then be included in part of the application review itself to determine whether the application can be approved or not. Just because a statement of concern is included as part of an application review, that does not mean that we will decide to hold a hearing on it. Under the Responsible Energy Development Act, we consider a number of factors whether deciding whether to hold a hearing. The factors that we now consider include whether the person has demonstrated that they can be directly and adversely affected, whether the statement of concern is frivolous or vexatious in nature or is without merit, but whether the AER has determined that the company has already addressed the concern that has been raised, if the application is one that the regulator can make a decision on immediately or on an expedited basis, the circumstances exist to disregard the statement of concern, the concerns have already been adequately addressed in another hearing or proceeding, the parties have made efforts to resolve the issues in question, the Crown has requested a hearing to address the impacts and mitigation on First Nations communities, and whether there is minimal or no adverse impact on the environment. So these are all things that the AER has to consider with respect to an application before we decide whether to hold a hearing or not. We can also decide on the appropriate forum of any hearing, including what important evidence needs testing, the number of parties who may participate, the location of the participants, the number and types of issues to be addressed, and the type of authorization being sought. If the AER does decide to hold a hearing, any person, including those who filed a statement of concern, may request to participate. Now, as always, the AER strongly encourages the use of ADR to try and solve issues before or instead of going to a hearing. It's a key priority for both the AER and the GOA, and we use it as a tool to achieve better decisions by resolving issues and minimize the number of issues prior to going to a hearing, or to lessen the reliance on the formal hearing process. Types of ADR can include facilitation or mediation carried out by our staff. Hearing commissioners now also can conduct ADR or can direct that ADR takes place. And ADR, of course, is available at any stage in the application process, and it always has been. We determine who may participate in the ADR for any dispute before it, and we actually can now direct parties to go into ADR in certain circumstances. And finally, just a quick blurb on publication of decisions. So, of course, now there is Section 33 in RETA, which says that the AER will publish notice of decision. There's also a second part of that says that we will provide direct notice of decision. So any application where there has been a statement of concern filed, the AER will now, in addition to notifying the licensee, which you all get, of course, the notification when the license comes through, the AER will also notify anyone who's filed a statement of concern against that application that the application has been dispositioned. AER decisions are published on our website. There is a decisions page. It's not in the systems and tools that is currently being built, and that page will be included in a future release. But any decisions that we currently publish are all in one spot on our webpage.